The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, first case we're going to hear this morning is Hannah versus United Parcel Service, and Mr. Glazer, I think you're up.
Yes, Your Honor. May it please the court, good morning. My client, Mr. Hannah, is a long-term employee for the United Parcel Service. He's a truck driver, he's a deliverer. And the issue in this case is whether or not the district court committed clear error when reviewing the record for summary judgment on the employer's motion. It's a pretty simple issue. The question is whether or not the evidence supported jury trial on whether or not UPS offered Mr. Hannah a reasonable accommodation. Now, as far as the elements on appeal, we don't have an issue as to whether or not my client had a disability. He had right hip bursitis. We also don't have an issue as to whether or not there was a denial of what my client wanted, which was another truck. He wanted a Dodge van or a vehicle with a softer suspension. The question for your honors today is whether or not, when the district court decided that the employer could not offer Mr. Hannah the ride he wanted, the truck he wanted, whether or not that was in contravention of the evidence that we introduced.
Let me just clarify just on that point. I didn't understand the employer to say they couldn't provide the truck. I thought they concluded, he requested a smaller truck with softer suspension. They concluded that the route could not be served with one passing with a smaller truck. He would either have to double up, come back to the center and reload, or they would have to service that route with somebody else helping. That's what I thought their reasoning was. Is that right?
Absolutely correct, Your Honor. And let me clarify, if I may. The UPS, the employer said, were we to grant you your requested accommodation, it would violate the collective bargaining agreement. Now, let's assume that
I don't want to keep correcting you, but I think you want to encompass fairly what their position was. I'm not sure that their main point was it would be a problem to bring somebody else and expand his job beyond, have him cover his own route plus part of Mr. Hannah's route, or Mr. Hannah would have to double back, go back to the center, reload and go, and that would take him beyond the normal hours of operation, and both of those were problematical, wouldn't you think?
well, Your Honor, that's where we have the disagreement with all.
Okay.
That's the issue. We put into evidence that it would not have resulted in the imposition that the defense suggests. That's our argument. And in support of that, we did offer substantial evidence. We contend that the evidence we offered presented a jury question on whether it would have been the imposition that UPS claims. To wit, we had an affidavit from a co-worker, Mr. Owens, that said, look, this truck was available on the lot. I used it in 2018. It was ready. It was available. That could have been offered.
So before, I have a question about that, but before we get to that, am I right, it's taking up something Judge Niemeyer said, did your client ever request an accommodation other than having a smaller vehicle? Is there any sort of proffer that he said, I'd like something that's not a smaller vehicle? Or is that the only accommodation he ever asked for?
He did ask, Your Honor, for temporary alternative work at one point, and I believe that they had allowed him that as far as they could under the temporary, under the collective bargaining.
So for the things that are an issue between the parties right now, the only request is for a smaller vehicle?
Yes, Your Honor.
Okay, and then, so can I ask you on the vehicle, you said there's an affidavit that says there is a smaller truck, but to pick up what Judge Niemeyer was saying, I don't necessarily hear the employer's argument to have been the reason we couldn't do that reasonably is not because there literally wasn't a truck. It was that this won't work because either your client will have to double up and that won't work, or we'll have to give someone else a double route and that won't work. So that whether there is or is not a truck does not seem to join issue with the employer's explanation of why this wasn't a reasonable accommodation.
So to answer that question, Your Honor, when UPS denies an accommodation or grants an accommodation, and this is in the record, it has to document what it did or did not do concerning a request for accommodation. It has to support that with records.
But that's an argument that they failed to prove the reason they gave. That doesn't seem to renew the relevance of the existence of the smaller truck. That's an argument that they inadequately documented the reason they gave.
Yes, Your Honor, and it's our position that they didn't offer sufficient proof for denying the truck. To cut to the chase, that is our position, that we had enough evidence for a jury to determine that there was a question as to whether they sufficiently documented and proved that it was unreasonable to deny my client his requested accommodation.
I didn't understand that. I thought your argument was that the reasons they gave were not serious, that could have been taken care of or something, but the testimony was undisputed as to what they met and they discussed it, and then they advised him, and it was undisputed as to what they determined. As they explained at trial, what they determined was, in the district court, they explained that it was a truck capacity problem.
Yes, Your Honor, and that, I would submit, was an issue for fact. It was an issue, as a matter of law, the district court said, well, that's conclusive, that the truck capacity, we showed that he couldn't meet it. It's our position that there was a factual issue on that because they never attempted to see whether or not the packages would fit on the truck, and they never allowed him a trial run on the route. That goes to the heart of our argument, is that we believe that the evidence showed a question. He testified that he could do that, and if they gave him the truck, he could complete the run without violating the collective bargaining agreement, without imposing and requiring people to double their routes, and without requiring him to violate safety rules. That's really the whole centerpiece of our issue with the district court's ruling. We wanted our shot at a trial on that. We wanted that to be submitted to the jury. We think that is an issue of fact and not of law, and that really centers around why we appealed this, because
What is the issue of? The issue of fact is whether or not he would have in fact been able to do the route using a smaller truck. You think that's the genuinely disputed material fact?
I think the disputed fact is whether or not it would have been reasonable for UPS to provide him with the vehicle he wanted. I mean, in other words,
let's say that they had given him a shot at doing it, and let's say they had been particularly generous and they had given him a week of a shot in doing it with the smaller truck, and let's say that after a week he had not successfully completed the route within the time allowed. Could they then deny it on the grounds that we've now demonstrated this is not going to work, it's not a reasonable accommodation, or do you have some other argument about why?
Okay, I have an argument about, first, I think they could deny it, but I would think we would have an argument under the United States U.S. Airways Barnett case, which basically says if you can show that there are exceptions, in other words, if it violates the collective bargaining agreement, it's presumptively unreasonable, but you can show that there are exceptions. For example, if UPS were able to allow him to do this without infringing on other workers' rights, or they had done this in the past. And that really gets into the factual dispute here, where we're saying it may very well have been a violation, but it might have been a situation where this would be an exception to that. In other words, under the U.S. Airways Barnett case. That's what we're saying.
But wouldn't it be your burden? I mean, I agree with you that if they say the CBA would forbid us from doing that, and then there was evidence that they make exceptions to the CBA all the time, maybe that defense doesn't work for them. But isn't it your burden to introduce that evidence? I mean, just because your client asserts that what they're saying is not true, I'm not sure it creates a genuine disputed material fact.
I understand, Your Honor. And we're saying that in addition to my client's testimony, that there was other testimony and evidence as well, in addition to my client.
There's evidence that they violated the CBA for other people in the past?
No, there's not on that, Your Honor. No, I did not mean to intend that. What evidence that it would have been reasonable for them to allow him to continue to do this route. In other words, I want to address, I don't want to interrupt you. I want to address a finding of fact that I thought was pretty dispositive here in this case, where the court said, look, Mr. Hanna testified that this would have violated the collective bargaining agreement. And we pointed out in the record, that's not what he said. A counsel asked him a hypothetical, and Mr. Hanna said, well, if that were the case. It's our case that he did not dispositively testify that if they allowed him this, it would have violated the agreement. That's where we have one of the disputes. In other words, the judge made a crucial dispositive finding of fact that was clearly wrong and should itself result in reversal. That was part of
do
what
you-
our argument was.
Do you agree that the employer doesn't have to give the particular accommodation that's requested? So even if your requested accommodation was reasonable, the employer can choose a different reasonable accommodation?
I would, to the extent, as long as it's not unreasonable. In other words, if Mr. Hanna asked for something and the employer says, we can't do that, they would have to show it's unreasonable. But yeah, the law.
Well, do they have to show that what he asked for is unreasonable if they offer something else that is reasonable?
I would take the position that has to be, they have to show it's an undue burden,
But don't you, I mean, you have to show that what they gave him is unreasonable, not just that they gave him something different than what he asked for.
Yes, Your Honor.
So do you want to talk about why what he received was unreasonable?
Yes, Your Honor. What he asked for was a different ride. What he got was basically a leave of absence, a medical leave of absence. Now, the court talks about how that was a reasonable accommodation, but my client did not ask for that. When he was on the medical leave of absence, he wasn't getting paid for that. He did not want a medical leave of absence. He wanted to continue to earn a salary. And that's the reason we're here, because he challenged that. He didn't want to be put on a medical leave.
Is that the question? Is that the legal question for whether it's reasonable or unreasonable, is whether that's what he wanted? Or I thought the question had to do with if it's a reasonable accommodation, like here they gave him time off so that he could heal. That might not be reasonable if you have a condition that is never going to get better, right?
Yes, Your Honor.
But they gave him time off to heal and recover, get treatment, and then he came back to his job.
He did, Your Honor. But we're saying that he didn't need the time off to heal. He could have driven with the truck that he wanted. I submit it's a question of fact here.
Well, so let me get. I realize there's maybe a question about whether an unpaid leave is a reasonable accommodation or not. So let me give you an accommodation that seems clearly reasonable. Let's say they say we can't give you a truck, but we'll let you work in the office for the same salary. We'll pay you the same amount. The job is a totally pleasant office job. And he says, but I don't want to work in the office. I want another truck. In that situation, just basically to repose Judge Rushing's question, does he have a claim there? If what they give him instead is unquestionably reasonable, does he have any claim that they didn't give him the one he wanted?
I would agree that in that situation, if he receives an office inside job and he's receiving the same salary and he's doing it, then in that case, I don't think his refusal would be supported in that case. I think that presents...
Well, does his refusal even matter? Or does the employer say, I gave you a reasonable accommodation. I've satisfied my duties under the ADA?
Well, whether he refuses or not, I think that would satisfy, again. But I think that goes, in this case, with all due respect to the damages here. I mean, in this sense, the damage was he wasn't earning the salary he wanted. And that's...
What is your best case for an unpaid medical leave of absence is unreasonable?
I believe it's... I mentioned this in a footnote, Your Honor. Let me find it. I believe Myers versus Hose, 4th Circuit, 50 F3rd 278, hold a request for indefinite medical leave without any assurance that the employee will be unable to fulfill her position's essential functions upon return is unreasonable.
Oh, is it an unreasonable request by the employee?
I honestly am not sure which way it went in that case. I admit, I don't remember whether it was by the employee. I apologize.
Anything else?
No, Your Honor.
All right, thank you, Mr. Glazer. You have some rebuttal. Why don't we hear from Mr. Wallace?
Good morning, Your Honors. May it please the court. Rick Wallace with Littler Mendelsohn on behalf of United Parcel Service. Your Honors, there is one overarching and undeniable truth that has gone unnoticed in this case by, I think, Mr. Hanna, and that is that it is undisputed that United Parcel Service, UPS, accommodated Mr. Hanna in every way and did so reasonably and successfully. And we know that because Mr. Hanna continues to work for UPS to this very day in the same position at the same rate of pay. Actually, he's making more now than he was during his period of temporary disability. And they accommodated him in a number of ways. He requested that they replace the seat in his truck. They did that. When his hip bursitis was diagnosed, they, and they're, as part of the contractually bargained union agreement, they gave him alternative work within the parameters permitted by the contract. And then when that ended according to the negotiated terms of the contract, they gave him a leave of absence for which he sought and received short-term and long-term disability pay until he was able to return to work. He returned to work successfully and works there to this day. So
Mr.
what
Myers,
this,
I know there are cases that say that an unpaid leave of absence can be a reasonable accommodation, but do you know of any of those cases where it was, I know of cases where the employee requests an unpaid leave and it's said that that's a reasonable accommodation. Do you know of any cases where an unpaid leave is granted over the objection of the employee and that's held to be a reasonable accommodation?
No, Your Honor, and actually to that point, when Mr. Glazer was talking about the Myers v. Hose case, every case cited by the appellant in their brief dealing with that issue about whether a leave of absence is going to be a reasonable accommodation is in opposite to their position.
It just, I guess I'm thinking about even the findings that accompany the ADA that talk about one of the harms of being disabled is people assuming that you're unable to work, and there's even, I think, there's a statement in the ADA's legislative history that says, like, not working could be one of the truest definitions of being disabled in the United States. And so it seems a little strange to me that an employer could say, here's our solution to the fact that you can't do the job without some change to the way our workforce works. How about you stay home and we not pay you? And it seems a little weird to say that is a reasonable accommodation of someone's disability. Stay home and we won't pay you.
Well, Your Honor, perhaps if that was the finite, out of the gate, that's all we're going to consider, then perhaps that could be an issue. But that is not the factual case here. That's not, the undisputed record is that they engaged in a lengthy interactive process with Mr. Hanna, whereby he was permitted to provide information about his medical condition, how it impacted his ability to work, and what his requested accommodations were. And as we all know, what he requested was a smaller truck. It is absolutely undisputed in the record that UPS then engaged in a very deliberative evaluation as to whether it could in fact grant the precise accommodation that Mr. Hanna requested. And as part of that, it wasn't just one person. The testimony, it was, the undisputed testimony was from Chris Westfall, who was their human resources manager. You can find that testimony at page 705 to 708 of the appendix, Your Honor. It was a committee. It involved human resources, the labor team, an occupational health nurse, and counsel. And they examined all of the factors and parameters surrounding that request. And as Judge Niemeyer noted earlier, one of the overriding problems with that request was twofold. Well, first, there's a factual, it's undisputed that both the plaintiff, Mr. Hanna himself, admitted, and then the undisputed testimony in the record from UPS's fleet manager was that those trucks did not exist at his work site. But
then, so when I was reading the record about that, it's a little confusing because, like, to me, the record was unclear to me whether work site means, like, literally the place he works or there's not one anywhere near the place. I don't know how UPS is structured, right? I don't know how close these other trucks are or not. And the record doesn't seem super clear on that question.
Sure, well, Mr.
It seems
Garlow.
to me that's a pretty thin thing, because if you have those trucks anywhere in the area, it's not a big deal to just drive it over to the location. Seems to me that might be a question of reasonableness if that was the only reason you couldn't drive it 30 miles or 40 miles or whatever it is for.
No doubt, Your Honor, and that was not the overriding reason that they were unable to provide that accommodation. As has been recognized, there was a bargained for collective bargaining agreement that governed the terms of Mr. Hanna's employment. And part of that is all of the routes that these UPS drivers are on, including Mr. Hanna's, are bid upon according to seniority. And they are assigned to the drivers pursuant to the terms of the CBA based on seniority. So, and once that happens, the undisputed testimony in the record is that a specific package truck is assigned to that route based upon the size, length, et cetera, of that route. And the UPS human resources person even admitted, yeah, we can move trucks around, but they have to be of a size and type that will accommodate the contractually bid upon route. And it's just common sense, Your Honor. A big brown UPS truck like we're all familiar with holds a whole lot more packages than a Dodge pickup, which Mr. Hanna was requesting. And so when they were evaluating whether they could allow Mr. Hanna to continue on his contractually bid upon route with one of the smaller trucks as he requested, it became very clear to the group that was reviewing it that that would create a number of problems and violations of the collective bargaining agreement. And it was twofold. Because it would be so much smaller, they determined that there was no way that a pickup truck is going to hold as much as the big brown UPS truck. And so there were two alternatives that were considered. One would be that they could have other drivers assist on that route to help with the package deliveries. And that would have created a violation of the collective bargaining agreement because they would be pulling those drivers off of their contractually bid upon routes and moving them to a position that they neither wanted nor bid upon. So that would have been one CBA violation. The alternative was that they could allow Mr. Hanna to make multiple trips to and from the loading distribution center with a smaller truck. And that was ultimately determined when evaluating the logistics and the collective bargaining agreement that that would likewise create a collective bargaining violation because Mr. Hanna and other UPS drivers, according to the terms of the CBA, are contractually limited to no more than 9.5 hours of dispatch. And these routes are planned basically to the minute. I mean, to the point that UPS trucks try to avoid left turns if possible, because you have to turn across traffic, and it slows things down. So having him going back and forth to the loading facility multiple times during the day would have then put him over 9.5 hours of dispatch, which would have been a separate violation of the collective bargaining agreement. So when they did that comprehensive evaluation, it became very clear that there was no way that they could provide a smaller truck to Mr. Hanna without violating the terms of the collective bargaining agreement. And it's black letter law under decades of ADA jurisprudence that an employer is not required to violate a collective bargaining agreement as part of the accommodation process. So what was ultimately decided upon is exactly where we are, which is that the only accommodation that worked was a leave of absence. And so he was out for 7 or 8 months, if I recall correctly, during which he received disability benefits. And when he was released to return to work, he put him back to work, which satisfied the spirit, intent, and letter of the Americans with Disabilities Act.
I mean, you could have just paid him while he was on this leave that you decided to gift him with. Would that have been a reasonable accommodation?
Well, Your Honor, he did.
No. Did UPS pay him or did the unemployment compensation? Who paid him when he was on leave?
UPS provides short and long-term disability benefits, of which he availed himself.
That were directly funded by UPS?
They were insured products for which UPS pays a portion. And I think for short term, they paid all of the premiums. I think the employee had some contribution to the long term, or vice versa. But he was, in fact, it's inaccurate to suggest that he had no income at all during this period. He was paid 70% of his normal salary, so he still had an income.
So I guess the question is it possible to rule for you in this case without deciding that an unpaid leave of absence to which the employee objects is a reasonable accommodation? Is there a way to rule for you without having to decide that question?
Well, yes, Your Honor, I believe absolutely there is, because if you just look at what happened, well,
I guess you could just say the one accommodation he requested the employer showed was unreasonable.
correct. And what this case is ultimately about is that Mr. Hanna believes that the circuit court erred and that UPS violated the law because it didn't give him his precise accommodation
Well,
that he
I
requested.
thought, in my understanding, it's a little more complex, but I think the prima facie case requires him to show that there was a reasonable accommodation. And then the employer has the burden to come back and say that it's unreasonable or it's a burden on the business. In this case, the question is the accommodation he requested turned out not to be reasonable, and that would then undermine the prima facie case, wouldn't it?
That's correct, Your Honor, and you actually...
I don't know if that's so. I'm just trying to address a little bit of the through questioning the question that Judge Heitens raised, but there's a blur in my own mind between the burden that he carries in showing the reasonableness of accommodation and the defense that the employer has to provide once that burden is carried.
Certainly, Your Honor. Yes. So, and that is an important point in this case. It is, in fact, Mr. Hanna's burden to show that that a reasonable accommodation existed. And we've discussed how it's undisputed that his precise accommodation was not reasonable because it would have been violative of the collective bargaining agreement. And part of the problem with one of their points of error is that they now argue, and Mr. Glazer said, well, he should have been given a trial run or some sort of test period. That is not something that has ever been part of ADA jurisprudence, and in fact would shift the burden to the employer to then demonstrate and basically have to exhaustively test every possible accommodation in order to then determine something was reasonable or unreasonable. So it is an impermissible burden shifting as well with this argument that UPS was somehow obligated to do some sort of test run. And at the end of the day, Your Honor, like I mentioned at the outset, we know that it was reasonable and a successful accommodation, this leave of absence, because there were no other possible accommodations, including his precise accommodation, and it worked.
Could I ask you that? Why wouldn't it have been possible to give him what I would just colloquially call a desk job during this period of time? Would that have also violated the CBA?
Yeah, that would have absolutely, Your Honor, because every position, whether it's inside clerical work, whether it's the folks loading the trucks, pre-sorting the packages, the drivers on the road, those are all bid upon positions pursuant to the collective bargaining agreement that are seniority based. And that's in the record.
I thought the evidence was not that, but that there were no vacancies.
Well, I was getting to, yes, Your Honor, that is also true. Well, it's both. They go hand in hand.
But it seemed to me if there was a vacancy, he could apply for it, couldn't he?
Yes, if there was a vacancy,
So what you were just saying is not a barrier. In other words, if there was a vacancy, he could have done a desk job.
Absolutely, Your Honor. But it is undisputed in the record that there were no vacancies, and that's what I was getting to. So because all of these are contractually bid upon positions, if there's not a vacancy, then he would have to displace somebody from a contractually bid upon seniority awarded position. And under the terms of the collective bargaining agreement, the only time there are bumping rights, meaning obviously the ability to bump somebody out, an incumbent out of a position in which they already are slotted, would be if he had been economically laid off. And that is undisputed that did not happen. So because there were no vacancies, it would have been violative of the CBA to put him in one of these other positions because he would have been displacing somebody without contractual support and would have been actually contrary to the existing CBA to do so. So, Your Honor, again, what this case is ultimately about is that Mr. Hanna believes the circuit court erred because it determined, rightfully so, that UPS provided a reasonable accommodation to the plaintiff, but it wasn't the precise accommodation. And every single point of error asserted by Mr. Hanna goes to that very point, that the error was because he didn't get his precise accommodation. And to find otherwise would be to literally turn decades of jurisprudence under the ADA on its head, because it's black letter law in this circuit and every other circuit that the employer is not obligated to provide the precise accommodation requested by an employee, so long as they offer a reasonable accommodation. And like I said here, they accommodated him in multiple ways, replacing the seat, giving him alternative work within the parameters of the CBA, and then when that was no longer possible contractually, and for the reasons we've already discussed, they couldn't give him a smaller truck, they gave him a leave of absence that allowed him to continue successfully working with UPS to this day.
Is that it?
Yes, thank you, Your Honor.
Thank you. All right, Mr. Glazer.
Thank you, Justice Niemeyer. I'll be brief. We're not asking to overturn decades of law, far from it. We're asking for a chance to present facts on the factual issue of whether or not it was reasonable. There's nothing to do with, we're not asking for overturning the law.
Could you address for me what your understanding is of the burden that you have in establishing a prima facie case and the burden the employer has in responding to it? And
Yes.
I'm focusing on just the accommodation aspect.
Yes, Your Honor. So we have to show that an accommodation existed that is reasonable. And we presented evidence to show. I want to address something.
What's the employer's burden?
The employer's burden is to show that it is an undue burden or that it's not reasonable. In other words, the employer has to say, look, we can't do this because if we do this, we're going to have to, as Mr. Wallace says, displace workers, or we're going to
And the
have to.
Supreme Court has concluded that collective bargaining agreement is a burden. I mean, you have to accommodate the collective bargaining agreements. And is that part of the assessment of the prima facie case or the employer's response?
I believe that goes to the burden shifting. In other words, the Supreme Court says it's presumptive. If you violate a collective bargaining agreement, it's presumed that it is an unreasonable request. But you can show.
No. I'm
sorry.
saying you agreed that the plaintiff has the burden under the act to show that a reasonable accommodation exists.
Yes, Your Honor.
Does that mean that you have to address the barriers created by the collective bargaining agreement?
No, sir. I think that.
You mean you can claim a reasonable accommodation exists even though it's in violation of the collective bargaining agreement?
I believe under the U.S. Airways case, I can. Yes, Your Honor. I mean, in this case, we showed that they had a fleet of vehicles, that they have all these trucks available, and that it would not have been an imposition for him to have to allow him to drive one of these trucks that had lesser cubic feet in it.
Well, as I understand, the pickup trucks had 300 to 400 cubic feet, and the big truck had 600 cubic feet. And so the question is, he would have to be able to do his route with, in other words, over the years he did that route. Was his truck half empty all the time? And there's no evidence to suggest that, because if it was about half empty all the time, then maybe he could have done the route with a smaller truck. But I'm sure UPS was careful in assigning the size truck to the route based on the number of the size of the packaging that they had statistically had to deliver. And so they assigned a 600 cubic foot truck to that route. And his argument is that he thought he might be able to do it with a smaller truck, but he didn't actually say that. He just said, I'd like to try. But it seemed to me it's almost common sense that he'd still have to make at least one return back to the loading dock.
Well, it's our position
And
that.
this is a country route, as I understand it. He had, some 30 miles just of driving before he got to a lot of the deliveries.
Correct. But in this case, a lot of the records that we wanted we couldn't get because
I'm talking about the substance of what we're doing. We can, if your appeal's dependent on the lack of records, then we can make that argument. But I don't understand that to be your argument on your brief. Your brief basically was that the accommodation he requested was reasonable, and that their response was unreasonable.
Yes, Your Honor. And we think that there's enough evidence here to submit to a jury on that, to listen to each side, determine whether my client is credible because he'd been there for, over a decade and a half, and to listen to the evidence that we presented and listen to the evidence that they present. In other words, as you well know, you've done this much longer than I ever hoped to do. It's a very minimal burden to resist a summary judgment, and we think we met that here, Your Honor.
Well, I know, but there was no credibility issue. He wasn't a dishonest guy, or he wasn't a malingerer. As a matter of fact, he sounds to me like an employee that every employer would like to have. But unfortunately, he had this injury, and the question is now, how do we take care of it? And he's back working there, and I'm sure both he and the company are happy with their ongoing relationship. But we have this interim where he had this injury he had to take care of.
Yes, Your Honor.
So the issue is whether the company violated the ADA during that period.
I understand, Your Honor, and I know my time is expiring. We just asked submit that it is a fact issue, and I appreciate your time.
Thank you. I think we understand.
Thank you, sir.
Our practice would be to come down and shake your hands. We would love to do that, and maybe Next term of court, we might be able to, but we're still under the protocols for this term. And so we'll greet you from the bench here and thank you for your arguments and look forward to seeing you again in court. Thank you, sir. Enjoyed your. We'll proceed on to the next case. Opioids and Young versus Bozzuto. And I guess, Mr. Taylor, you're up first, whenever you're ready.
Good morning, thank you, and may it please the court, Jonathan Taylor for the plaintiff.
You'll have to speak up a little bit. And
Sure.
Pick up speaker and then speak. We're across the room from you.
Yeah, okay. I'm going to try to reserve 5 minutes for rebuttal, if I may.
That's fine.
The district court below dismissed the complaint in this case because it concluded that the plaintiff didn't plausibly allege that she had suffered an Article III injury when the defendants personally discriminated against her based on a protected characteristic. That conclusion is wrong and should be reversed. This court should hold at a minimum that the plaintiff here has standing because she has alleged two things. Number one, she's alleged that she was personally subjected to unequal treatment by the defendants based on a protected characteristic of hers in violation of her individual rights. And she's alleged, number two, that this personal unequal treatment concerned something that mattered to her in a concrete way, namely access to and information about housing. And when these two things are true, personal unequal treatment that somebody has suffered as to something that matters to them in a concrete way, this court and the U.S. Supreme Court have consistently held that the plaintiff has standing to challenge the unequal treatment.
What is the sort of, I agree with you that in many ways to me this case entirely comes down to what do the words personally denied equal treatment mean, those words from Allen versus Wright in the Supreme Court. And I just sort of, I get a sense when I read the briefs that the parties are just talking past each other because you say that's what happened here is obviously being personally denied equal treatment. They say it's not. I mean, I guess maybe first, concrete question, what is the most analogous case from your perspective? Because the cases I can think about are, I applied to a school and I was evaluated under different criteria, or I wanted to bid on a contract and I was subject to different criteria. What is the closest case to saying I wanted to see an advertisement that I didn't see based on a protected criteria?
Well, I think this is kind of a modern version of a classic steering case where here you have a housing company that says to Facebook, don't send its information.
I don't want to keep budging, but
Speak up.
speak up.
Happy to. Yes, I'll
I
try
mean,
to.
be an orator.
Yeah, I mean, you have here a housing company that made an express statement to Facebook. We want to send this information to anyone who's interested except people who are older than 40. And solely because of that express statement indicating a clear preference to target.
But what's the closest case? So, I mean, you might say Havens, but in Havens, the person who was found to have standing was a person who was lied to personally. They said, do you have any housing available? And they were told no, and that was a lie. So that isn't really the case here either. So what, again, I guess I'll just ask it one more time. What is the closest case to saying, I wanted to see ads that I did not see, and that means I have an Article III injury?
Well, I mean, one case you could look at as the Comer case out of the Second Circuit. So there, it wasn't ads, but it was information about housing opportunities that the plaintiff wasn't told about. And she alleged in that case that she would have potentially made a different housing decision had she been made aware of that information.
When you say wasn't told about, as in someone didn't send her information about, or she went in and said, what housing opportunities do you have, and someone left off one of them?
I think it's closer to the latter, but I mean, I think all of the discriminatory advertising
But
cases.
that's a personal engagement.
It's a
In other
personal.
words, when somebody seeks it out, but she says, it's a little strange the way she's alleged her complaint, or you guys have all alleged the complaint. She says she was searching and was denied the opportunity, but yet her search never constituted any affirmative act. She basically was relying on her, while she was using Facebook, that a pop-up ad would be one that she'd be interested in. And so there was no suggestion that she personally requested something, was denied something. This is a little bit like driving by on the highway and seeing a billboard for a community that serves people 55 years and older. That applies to some and doesn't apply to others, but she didn't do a single search according to what I can. She didn't push a button and say, I could have looked here or looked there. She was waiting passively for Facebook to give her an ad that was appropriate. And it's a strange abstraction. In other words, these cases you cite are where people actually affirmatively were seeking something and were denied it or lied to or somehow personally affected. And I think the district court judge was troubled by that aspect. I think that's what was the core of his ruling, don't you think?
Yeah, and I'm happy to take on the district court's rationale. I will just say in direct response to your question, Judge Niemeyer, I just don't think it's an accurate reading of the complaint to say that the only thing she did as part of her housing search was sit passively at her computer and wait for ads to pop up. I mean, if you look at JA pages 14 and 15.
Did she actually go and search on Google or any other platform and look for rental properties?
Yeah, so she alleged, this is at page 14 of the joint appendix, that she regularly searched for rental housing in the DC metropolitan area during this time.
And there's no evidence that in searching for that, she was denied anything.
No, that's right, but she
was only denied the opportunity to see passively, to see ads that pop up while she used Facebook.
No, what she was denied was the opportunity to learn about available housing that she alleges she had no idea about until she was told about the discriminatory practice. And so,
But you didn't allege that she went to the site and could only see certain types, or she went to apartments.com, or the many, many sites for rentals that are available, that she was denied access to anything. You don't allege that.
No, but
you
that-
allege only that a pop-up ad for her age group didn't show up on Facebook.
I think that misunderstands with respect, Judge Niemeyer, the nature of the injury. And this really gets to the core of the district court's
Well, I'm trying to
analysis.
focus on the allegations first.
So I'm happy to focus on the allegations. I'm not running away from them. You can look at pages 14 and 15 of the joint appendix and then 40 to 45, and I'll just rattle off what I think are the most pertinent allegations. She was regularly searching for rental opportunities, both online and offline. She regularly used Facebook and visited properties to consider renting. She was not aware of these particular housing
All right,
opportunities.
let's take
Had she
those,
seen them, she would have-
allegations. Is there any suggestion, and in those activities, she was denied access to any ad or property?
Yeah, this very case. I mean, the
This is not a search. These are passive ads that appear on Facebook. The search would mean going out affirmatively and pushing a button.
Right.
Or driving by.
But that doesn't mean that the information was wholly irrelevant to her. I could imagine if we were sitting
No,
here.
but the discrimination, if you searched it out and it was denied to you, that's a different type of injury.
I agree that would be
than-
more concrete. But here, I mean, the defendants came to her. They specifically said when they were interacting with Facebook, don't send this information, this housing information, regardless of whether people will care about it, to anyone over 40, even if they're in the geographic area. And that is the only reason why she was not able to see this housing
So
information.
can I ask you, could an apartment company decide to advertise exclusively on TikTok?
I think, the question there, that's a different theory of, the question on the merits would be whether that advertising campaign to an objective reader would indicate a preference. For
But I guess another way to say it is, what would an individual need to establish standing to challenge an employer a housing company advertising only on TikTok?
So I think I think you can answer that hypothetical either way and still rule in our favor here. I'll give my best crack at the hypothetical. I think you probably don't have as clear an argument in that case that someone has been personally subjected to unequal treatment, because all the defendant has done is, advertise.
And I guess the answer is anybody who wants to see those. But I thought, it seems to me that what the defendant could say is anybody who wants to create a TikTok account can create a TikTok account. And then your response is, but there are no old people on TikTok. And you say, well, that's not our problem. That's just how TikTok works.
Well, I think that certainly would be their defense on the merits, and they might very well win that case. But I think...
Well, no, I mean, if a person who didn't have a TikTok account brought such a lawsuit, I imagine the first question would be, did you ever try to create a TikTok account?
Well, I think the person would have to be first, an older person who claims that this is tantamount to age discrimination. And I think if that person could show that, look, they were in the same geographic market for housing, they were looking at the housing, for housing opportunities at that time, they were not aware of the housing opportunities that were advertised on TikTok, and had they seen those opportunities, they would have qualified for them and applied to them and obtained them, which everything that we have in the complaint here, I think they would have an argument that if there was no other advertising that was done, they at least have standing to challenge the practice, even if it's only standing to lose that case. And I think in our case, it's even clearer. There is a statement that the defendants made to Facebook to exclude everyone who is above a certain age from even being able to receive the information. And I think what the district court got wrong, it's a multitude of mistakes that the district court made, but number one is the district court just misunderstood the nature of the injury. It's not the inability, and the Supreme Court has made this very clear, to ultimately obtain the benefit, whether it's access to the housing or information about the housing. It's just being able to compete on a level playing field. The Supreme Court has made that clear in the general contractor set-aside cases, in affirmative action cases. Judge Niemeyer, an opinion that you joined a number of years ago, Price versus City of Charlotte, I'm embarrassed to say we didn't cite it in our briefs, I wish we did, made the same point. The plaintiffs in that case were white police officers who concededly were not eligible to
This is not a case about competing on a even playing field. You have to have an actual injury, and your claimed injury that you're focusing on this morning, it sounds like, is access to information, right? You're saying the information, maybe it wasn't denied, but it wasn't volunteered.
I would put it maybe a little bit differently. I think you're right that the information is part of the injury. I mean, ultimately what she wanted was to obtain housing. And the information mattered to her because it affected her ability to obtain housing. And I think in the Supreme Court most recently in its TransUnion opinion, I think maybe it cabined informational injury as an Article III injury, but it specifically said if someone is requesting information, they're denied that information, and that causes them some harm.
You just changed two words to me that I think is critical in this case. If she were denied something upon request, you fall within Haven and some of the Second Circuit case. But if she passively, if they advertise to the whole public, only to people who are between the ages of 20 and 35, and they advertise to everybody in the whole area, and she doesn't make a request and is not denied anything, she's not personally discriminated against. The whole group is. It's a societal problem. And the standing comes when she personally makes a request and is denied it, or she is personally injured. Now, in this case, it's denying an opportunity on a limited single platform, Facebook, to see something that she can see on every platform available there. She could type in the rental company's name, the apartment's name, rental names, brokers' names. There's just a whole panacea of opportunity to determine whether she's being discriminated against. But just the failure to have a targeted ad pop up, a targeted ad pop up and say that's caused me injury is sort of would be a reach, wouldn't it?
I don't think so. And Judge Niemeyer, if I could just give you a brick and mortar example that I think is logically indistinguishable from this case. So imagine that instead of advertising on Facebook, an apartment complex sent an employee down to the street to pass out flyers advertising available units and maybe a deal on those units, but said, don't give these flyers to anyone you see who's a minority. Only white people can get the flyers. And if someone walked by the street and they were a minority and they were interested in renting housing that otherwise would have applied for and qualified for that housing, I think it's pretty clear they would have standing to sue, and I don't think it would be a defense for the developer to say we have
They might, because you're personalizing it to a person who's interested. Now, how about you take your hypothetical, and there's a big sign in front of the housing and says, whites only. And a person drives by and says he sees that, he's African-American, he drives by and sees that and files suit. And he says, that bothered me because it was not offered to me. It seems to me he would have to say that he was interested in renting that unit, or he was denied it, or he was looking at that unit and that sign prohibited him. There's got to be some personalized injury, right?
Well, we have a couple of different responses, Judge Niemeyer. The first point is that is not different, that is not any more personalized. I mean, it's just the digital equivalent of that face-to-face interaction. It is otherwise on all fours. The second point is, we have alleged in this complaint
I
that
want to
you
let you finish your answer, but just to be clear, it's not on all fours. The stigma here, your alleged stigma is not on the face of the ad. It's not an ad that says no old people wanted for this apartment. It's just an ad that says we're renting apartments. And the stigma comes at some time that's not disclosed to us in the complaint when she learns from someone else that this is how Facebook algorithms work. Right, and that's, I mean, a stigmatic injury is very different here, but you had another answer.
Well, and the ads in my hypothetical are also facially non-discriminatory, and a person who walks by and isn't handed a leaflet wouldn't have any reason to feel stigma because they wouldn't have been aware of the reason they didn't receive the ad, but if they later discovered that the reason they didn't receive the leaflet is because that complex had a policy to categorically exclude anyone who's a racial minority from receiving it, I don't think it would be an answer to say that the content of the ad itself is non-discriminatory. The only reason you didn't receive the ad is because of a protected characteristic.
Well, then you have a question of, right, is it a personally felt stigma issue, or is it everyone in society, someone who lives in Alaska would also feel a stigma because, these advertisements were only being handed to certain people in, the DC area.
That's right, and
But
we're not.
my point was for this sign in front of the
Right.
complex.
Yeah, I think that is right, and we're certainly not coming to the court with a theory that would allow anyone in the country who's over the age of 50 and uses Facebook to sue these particular defendants alleging discrimination for these particular ads. It's much more particularized and concrete for that. And Judge Niemeyer, just to complete my response to your question, I mean, there are allegations in this case that rise to the level of, I would have applied to X, Y, Z. That fit within my budget. I didn't know about these opportunities. I would have applied. I wasn't made aware of them. And that's a competitive imbalance. And I think it
But not being
strains.
made aware of them, if you made no effort at all, it's just passively. These are neutral ads, and she doesn't know how they're targeted. I mean, they could be, a lot of medical ads are targeted to older people because older people suffer more medical ads than injuries than young people or have more sicknesses.
Right.
In other words, the problem is not that maybe it's not a good practice. The problem is whether your client, by not seeing neutral pop-up ads of a particular category, discriminates against her personally. And the answer is if she pursued it and was denied it or discouraged or whatever, but she says those ads were her entry to the whole market, which can't be so because she said she searched and drove around and she must have gone on Google, and there's no suggestion that those ads were the gateway, those opportunity
No,
ads
and
were
that's
the
not our-
gateway to these other
Right.
these other apartments that existed.
Yeah, and I just want to be clear about this. That's not our theory. Our theory is that she was already in the market and there's a competitive imbalance. And I think the competitive
And
imbalance.
so she didn't see an ad. That's her. It's sort of a negative. It's not that she was denied anything. She didn't see an ad pop up on a particular platform,
Well,
whether it's
I would-
TikTok or Facebook or some other platform. But she never asked them.
Well, that's not the, I mean, not generally the way that ads work on the internet, but I agree you can go to Google and do an independent search for that. But I find it a bit rich that the defendants here are suggesting that their own decision to spend money on these ads had no effect in the real world. It didn't result in people finding out about their properties and applying for those properties and ultimately securing those properties who wouldn't have otherwise done that. That's the logic of advertising. And it's frankly offensive to, sort of for the other side to respond with almost mock derision at the notion that someone might actually care about listening to the message that they're paying to tell them.
Could an assisted living facility advertise only to persons 55 years and older?
Well, I think that if someone is not in the market to, is younger than 55 and doesn't need those services, then I think that you would have a very strong argument that that person doesn't actually have standing to challenge that practice, because even if they're sort of discriminated against in a personal way because they're screened out from receiving those ads, that discrimination is sort of just discrimination in a vacuum. It's kind of like the ADA tester case that was before this court a couple of years ago, the Griffin case, where if I may just spend a minute, I realize I'm blowing past my time here, but just for the court's benefit, the facts of that case where you had someone who was visually impaired trying to access a website for a federal credit union, the Department of Labor credit union, that she was sort of ineligible to, barred by state law from being able to access those services, and claimed that that the website wasn't accessible to her because of her disability, and sued based on that. And Judge Wilkinson, in a very thoughtful opinion, said, look, this isn't really being personally subjected to discrimination because you're legally barred for an independent reason from being able to access the services, in the same way that there was a geography barrier in Allen versus Wright, and there would be a geographic barrier here if we were a plaintiff outside of the DC area. But, and there I think there was also a real risk of opening the doors and allowing for manufactured standing. You don't have that in this case, and so I think it's meaningfully different.
All right, I think you have some rebuttal time. We're a little over the time already. Mr. Keneally.
Thank you, Your Honor. May it please the court. My name is Michael Keneally. I represent JBG Smith, and I'm arguing today on behalf of all four defendants in this appeal. Before the district court, plaintiff alleged 4 injuries, and the district court correctly and methodically explained why each of those 4 did not support standing given plaintiff's allegations. On appeal, plaintiff, at least in the appellate briefing, barely challenged that conclusion and instead made this argument that she did not need to show an injury within those 4 categories because it was enough to allege unequal treatment. Now, I don't think she's preserved that new argument for appeal, but even if she had, it would not change the analysis and not provide a basis for reversal, because even today, plaintiff's counsel admits you still need to have a particularized injury, being personally subjected to the unequal treatment, and it needs to be concrete. So I think even under the new framing in the appellate briefing, the court has to affirm the dismissal of plaintiff's case because she cannot show both of those 2 requirements of Article 3. Before I get to that argument, I would like to briefly address the district court's grounds for dismissing the complaint.
Mr. Keneally, can I ask you 2 framing questions that I think are necessary to sort of set up another question I'd like to ask you? So for purposes of the standing inquiry, I suspect your clients do not agree with this, but I guess for purposes of the standing inquiry, we have to assume that what you did here was totally illegal, right?
No, I disagree that you
For
have to do
standing
that.
purposes, we don't have to
Correct.
assume that what you're doing is illegal?
Yes, because, in the following sense, Your Honor, not because of the dispute about whether she can prove the facts that she's alleged, and we agree that that's merits, but you still, if as plaintiff is doing, arguing that the legislatures of DC and Montgomery County have elevated to a concrete injury a particular type
Oh,
of
no,
statutory
I
discrimination.
understand that legislatures can't create Article 3 standing where it doesn't exist.
Sorry, that wasn't my point, Your Honor.
Okay.
Although I do agree with that. My point was that if the legislature is doing that and is creating a right against certain treatment, and that's unequal treatment, and that's going to give rise to discrimination, I think even plaintiff would admit you have to look at the DC statute here or the Montgomery County provision to know that age is a protected classification. Otherwise, I mean, You could argue as one of the ads was targeted to pet.
If that's a problem, so let's say someone alleged age discrimination is illegal and age discrimination is not in fact illegal. I agree that plaintiff definitely loses, but she loses because her claim fails on the merits, not because she doesn't have standing.
Well, could I give you an example based
Sure.
on another type of ad targeting that's mentioned in the complaint? Some of these ads say that the reason why I'm seeing this ad is because I like pet lovers. If a pet lover came in, or someone who hated pets, came in and said, that's unequal treatment to me, they wouldn't have standing. I
They
think
absolutely would have standing. Well, they would either have standing for the same reason she has standing, or they'd lack standing for the same reason she lacks standing. But if the reason they failed is because there's no law against hating pet lovers, that's a merits problem. That's not a standing problem.
Okay, well, I respectfully disagree, but I'm willing to.
What case says that is a standing problem?
Well, in all of the cases that deal with statutory rights, the court still will look to the nature of the statutory right, because standing depends on the nature of the injury.
Okay, let's assume I disagree completely with that.
Okay.
So the second question that I have is, you also have to assume that the analysis here is literally the same if instead of checking a box that says no old people, your client had checked a box that says no black people, right? From a standing perspective, those are identical issues.
Perhaps, but I would argue that what it takes to allege stigmatic injury might be different in those two cases.
Sure, but from a perspective of all of the, whether you're denied unequal treatment when you don't see an ad that maybe you want to see, maybe you didn't. It
Sure, from
literally
the
does not matter that
information
it's
and
no old
housing
people.
access, yes, I would say that those are
Okay,
all.
so let me give you this hypo then, which is sort of similar to the one that your colleague did, but with a different twist. So assume that you have a town with 10,000 people, and assume you have a real estate company that has the budget to send flyers to 2,000 of the town's 10,000 residents. So under this hypo, 4/5 of the town is not getting a flyer, 1/5 of the town is getting a flyer. And before they send them, they have a marketing committee make sure, don't send any of these to black people. Just make sure that we've only got a budget for 2,000 people, but we only want white people to get these ads. Pull all of the black people out. Are you saying that not a single person in the town would have standing to challenge that, including black people who are actively looking for housing?
No, Your Honor, and there are two reasons, I think. One is, I still think we have to distinguish between stigmatic injury, which is a dignitary harm, and economic or informational injury, which I think is different. And so I don't want to talk about, I'm happy to say that the stigmatic injury in that case seems a lot more palpable to me than what is alleged in this complaint.
How?
Well, the only thing that's alleged in this complaint on stigma is on paragraph 104, page JA45, and it's a conclusory resuscitation of the discussion in Heckler versus Matthew that says that the general public, plaintiff, and members of the proposed class have been harmed by virtue of being segregated, classified, and treated in an unequal manner by defendants. I don't think that there's any substance, any factual substance to that allegation that distinguishes plaintiff's injury from the general public's injury. So in that case, or in this case, I think you have an abstract stigmatic injury of the type that under Allen versus Wright is not permissible. But to go back to the informational side of your hypothetical, I would say, I'm not sure I got all of the facts of it, but it sounds like in that case, the information is actually limited. There are only a certain number of flyers, and in not getting those flyers, the plaintiff or the potential plaintiff.
4/5. They don't have a budget. They don't have a budget to blanket the town in flyers. They're going to send it to 1/5 of the residents of the town, and they systematically screen out people based on a protected characteristic.
And in that case, it sounds like the opportunity to learn about the property is being meaningfully hampered by not being eligible to receive.
Oh, no, they're on apartments.com. All of that other same stuff is true. You can Google them, you can find them on apartments.com, but they've only got money for 2,000 physical mailers.
And then the plaintiff does not receive one of those mailers, but
sure.
but what is the plaintiff doing with respect to apartments.com? Are we assuming that the plaintiff has the ability to receive information about these opportunities?
Yeah, everything
every
about
other
this,
way?
literally this case is exactly the same, except it's race, not age, and it's physical flyers, not Facebook ads. Nothing else.
Then I think the stigmatic injury analysis could be different, but the informational injury analysis would be the same. And I think it's very important here to go back to the allegations in the complaint about the plaintiff's search. If you look at 14 and 15 of the JA, or 40 through 45, there are no allegations about what exactly plaintiff was doing, and even what vaguely plaintiff
But I guess
was
my
doing.
question, I take your point, and I think you're quite right that her allegations are fairly thin, but then I'm thinking about the way your standing theory works. Like, I guess my question is, her complaint doesn't say it. In your view, to the extent you are arguing that her complaint has insufficient information about what she actually did, what sort of information could cure the standing problem you have identified?
I think information that makes it plausible that it was difficult to receive this information that she's looking for through other means, including the means she attempted. I think that would help to show that her housing search was actually hampered by.
What if she alleged, what if she alleged that there was an ad, a special, that you only advertised on Facebook? You would agree she would have standing then?
There might still be a
20% off
causation
for people
problem.
you see these on podcasts or on the web sometimes, right? 20% off for people who click this link. Does she have standing then?
In the context of Facebook targeted advertising, there may still be a causation or redressability problem, but I do think that would be injury. If
The
there's
inability-
information that she wasn't able to get otherwise, that would at least be concrete injury. You might still have a question about whether it's particularized to her, because again, there's really no direct interaction between her and defendants. Her counsel said that defendants came to her. That's not true. It's not supported by the allegations. And I think the Griffin case that Mr. Taylor mentioned actually is helpful in figuring out what it means, to go back to your question at the outset, Judge Heitens, to be personally subjected to something. In that case, the opinion for the court said that personally subject means direct interaction. So if I'm passing someone on the street and they don't hand me a flyer, that's direct interaction. If I go to their website and their website tells me something that's false, or if I ask them for information
But
and they give me.
I go back. Why isn't this precisely the equivalent of passing someone on the street and they don't hand me a flyer? I'm scrolling through my Facebook feed. There's 1,000 people scrolling through their Facebook feeds, and some of them get this ad, and some of them don't. Why isn't that exactly like I pass someone on the street and they hand some of us flyers and they don't hand others of us flyers?
Well,
That seems exactly the same.
We have no reason to think from the complaint that the plaintiff was in the position of someone passing someone on the street, because we don't know. I mean,
She
there
was
are
a person on
dozens.
Facebook. What more do you need, or on Twitter, or on TikTok, or on any other online platform where there's a feed? I literally don't know why that's not exactly the same as a person walking down the street.
Well, there are, I think, by the complaint's own allegations, dozens of ads that are being challenged here, most of which are for properties that plaintiff doesn't even have an interest in. And that's just the defendant's advertising. There are also many other housing advertisers who advertise on Facebook.
Sure,
There
that is maybe an argument that you could have made a targeted motion to dismiss some of her claims for insufficient allegations against some of the defendants. But I don't understand how that's a blunderbuss attack on all of them.
Because there's no reason to think that she was coming so close to being in contact with defendants, except for their alleged targeting of the ads. She would have seen these advertisements that interested her. She might have seen other advertisements instead. She might not have been on Facebook except for 5 minutes a day and saw maybe 2 advertisements total in that period.
But I might only walk past the mall for 5 minutes a day, and if there's a guy handing out flyers during that 5 minutes and he doesn't give one to me, I don't know why that matters.
Well, in that case, you're in direct contact with that person.
It would seem to me that your concession may be too broad, because it seems to me merely passing, as Judge Heitens says, may be totally analogous just to the passive activity on Facebook. It seems to me what the hypothetical would have to include is where the person passing asks for the flyer, reaches his hand, and the person looks at him and denies it to him. Then it's personalized. But if it's just walking by and is not handed it, it seems to me that you're more analogous to your argument that there is no concrete harm or particularized harm, because somebody that's walking by may or may not have an interest. It's where they reach out and say, I'll take a copy of the flyer, and the person who's handing out flyers looks at them and withdraws it.
Thank you, Your Honor. I appreciate that. I'm trying to address these hypotheticals, which I confess I hadn't really thought of before today, too, kind of on the fly. So I appreciate that clarification. You could also imagine the person who crosses on the other side of the street from this person handing out flyers. I don't think that would be direct interaction either, but I think it would be closer to what the position plaintiff was in here. I think it also is incredibly important in this case that the information that's in the Facebook notices that plaintiff is complaining about not having received are just the information that these houses, these properties exist, and that their property companies have websites, and there are links to those websites. I think the plaintiff's own complaint in paragraph 7 says that she would have reviewed the defendant's websites. And that's how, presumably, she ended up being able to identify 6 properties that had the type of housing at the price point that she says she was interested in. Nothing in the advertisements themselves actually contain that information. And so even there, they do not contain the information that would have helped her on her housing search. All they would have provided was one way, a random way, to access the defendant's websites. Sorry, just looking at my notes here. I think the more analogous case on the competing on on an equal playing field rather than receiving an online advertisement would be so it's very easy to see how in cases like Backey and City of Jacksonville, not being able to compete for a government contract or a spot at a university that interests you is not being able to compete on an even playing field for the benefit you're interested in. Here, however, plaintiff's own admission today was that the ultimate benefit was housing. And there's no allegation that there was an unequal playing field for actually receiving housing. The only allegation is that there was an unequal playing field for receiving the particular Facebook advertisement that we don't have any reason to think was necessary in order to find out about the housing or apply for property. It would be more akin if we took the City of Jacksonville case, and instead of there being a set aside, there was a special outreach program for minority-owned businesses where they provided the same information that was broadly available about the government contracts that were being handed out, but also targeted outreach to a particular part of the population based on race. I don't think that that would give rise to concrete and particularized injury in fact.
Let me preface this by saying I fully recognize this is not this case, but I'm just trying to make sure I understand how the standing analysis would work here. Imagine a situation where there's something that's in extremely high demand, right? Taylor Swift tickets or something like that, right? And so they advertise it in a whole bunch of ways, but it turns out everybody knows this thing is going to sell out instantaneously, right? And so the ability to access the portal in a timely fashion is critical because in reality, if you don't get these in the first 5 minutes, you're never going to get them, right? And imagine they sent the advertisement to the young people 2 minutes before they sent them to everybody else. Now, the information is available to everybody. There's a website that tells you you're going to be able to order tickets on a certain day, but you can't do it until you have this link. You need this link. And they send that link to people 2 minutes earlier than another group of people, knowing full well that these are going to sell out in 30 seconds. Would a person who didn't get the ad have standing then? And if so, why? And if so, why is that different from this?
I think probably, Your Honor, based on my understanding of the hypothetical, and the difference that matters is that there is reason to think there's a meaningful advantage given to one segment of the population that another segment of the population is being denied. I don't think of getting a Facebook ad as really being a meaningful advantage because, especially when they're untargeted, they're usually of no relevance whatsoever. I think in this case, there are no allegations that these apartment buildings filled up before plaintiff found out about them. And that's usually, I mean, they seem to have been new apartment buildings with lots of vacancies, presumably. That's not usually how real estate works. It's not Taylor Swift, much to my client's disappointment. But I think that that's really the key difference there, is that there is a tangible and particularized disadvantage in getting the benefit at issue that's present in your hypothetical about Taylor Swift and is present in college admissions cases, in government contract set-aside cases. And here, given the non-rivalrousness of information, the fact that information is accessible all over the place, especially in today's digital era, and the lack of any allegations that despite that common experience, this particular information was not available or that better information would have been available on the Facebook ads. Here we don't have any of that. And so it's entirely implausible to think that the not being eligible to receive a particular Facebook notice for these houses is what caused plaintiff or in any way cause plaintiff to be disadvantaged in her search for housing, which of course ended in 2019 when she purchased a home. And of course, I will also just note that Facebook, according to paragraph 40 of the complaint, has revamped its entire way of advertising housing. So obviously there are damages claims in this case too, as well as injunctive relief claims, but I don't know how a request for prospective injunctive relief could be one that plaintiff has standing for, given that she's not in the market for housing any longer, and Facebook has completely changed the way it handles these advertisements. The other point, Your Honor, we've talked a lot today about how the allegations in this complaint are pretty thin. I think it's important to keep in mind the procedural history of this case, because this was the amended complaint that plaintiff filed here after seeing defendant's original motion to dismiss on standing grounds, and it came also after the dismissal of plaintiff's lawsuit against Facebook, raising a similar sort of theory based on ad targeting that was also dismissed on standing grounds. So any allegations, I think, that plaintiff could have made, I think she was on notice that she should make in this amended complaint, and she didn't seek leave to file a second amended complaint. So I think that given her opportunity to put in any allegations that she was capable of making, and the fact that these are the best she came up with, we would ask that the district court's judgment be affirmed.
All right, thank you, Mr. Keeley. Mr. Taylor?
Thank you, and may it please the court, just a few quick points in rebuttal. Number one, Judge Haytens, you're absolutely right. You assume the merits for purposes of standing.
It might be helpful if you.
Oh, yes.
Yeah. To hear you right.
Thank you, Judge Niemeyer. You're absolutely right that you assume the merits for purposes of standing. I don't think that's much of an assumption here, because there was clearly a statement that the defendants made to Facebook that explicitly preferred race, age. The second point is, Judge Haytens, you're also correct that the ramifications of embracing the theory advanced by the other side is that it's really open season on any kind of targeted ad campaigns online, excluding people based on protected characteristics, be it age, race, political affiliation, whatever it might be, so long as there's a website that's sort of open to all, that any kind of targeted advertising beyond that, no problem. And I think that really just underscores the consequences. My friend tried to suggest...
Can I ask you about, talking about assuming the merits, if we were to conclude that this were an injury, would we have to send it back for a causation analysis, like still on standing, not getting to the merits? Because, I mean, your opponents seem to also be making or claim to have arguments about how there's a missing link to substantiate the theory that your client would have ever seen these ads, given, I mean, if age and location are the only limits, was she getting any ads for housing on Facebook? How many were possible? How long was she on there? That these would have ever popped up.
Yeah,
We can't assume, I mean, we have to grant you the merits, but there seems to be a standing causation link for assuming that if the age limitation hadn't been on there, she would have received the ad.
Well, it depends on the nature of the injury. And the injury that we're relying on here, to be clear, is not the ultimate denial of the benefit, be it the ability to obtain housing or even information about housing. It's unequal treatment on account of protected status with respect to a person's ability to kind of compete.
So you're saying your argument is not ultimately that she was denied information, it's that she was treated differently.
With respect to the information that was pertinent to her, that's correct.
Well, why do you need to have information that's pertinent to her if the denial of the information is not the injury? If the injury is just I was treated differently.
No, well, I think there are cases that hold that simply being subjected to unequal treatment by whether a government or a private party based on a protected characteristic is itself an injury.
No, there are cases that say that can cause an injury. You misquote the cases. They say that can cause an injury.
Well, I think what those cases say is that a discriminatory practice can cause a concrete injury.
Yes.
But you have to be personally subjected to it.
Like being forced to compete on unequal terms, but the injury is being forced to compete on unequal terms.
That's right, but there's also, my friend tried to distinguish the race-based hypothetical by saying, it's different based on kind of a dignitary harm distinction. I would just note that this court has foreclosed that argument in the Griffin case. That was a case again involving a disability, and Judge Wilkinson said it is true that the complaint does not include the phrases dignitary harm or stigmatic injury. Ours does, by the way. But such a ritual incantation is unnecessary. Dignitary harms are readily inferred by allegations of unequal treatment. The court simply held that the dignitary harm wasn't suffered there, not because there was no kind of face-to-face interaction, but rather because there was a legal barrier that was akin to the geographic barrier in Allen versus Wright that prohibited the plaintiff from being able to access the services at all. Here, there is no barrier, that prevents that prevented the plaintiff from being able to, search housing, obtain housing opportunities, and so I think it's meaningfully different. My friend also said that, the only way in which an informational injury could sort of bear on the analysis is if the information were categorically denied. The plaintiff was categorically denied an ability to see the information. That's not correct. Again, the injury that we're alleging here is the ability to receive information on equal terms. And as Judge Wilkinson pointed out in the Griffin case, when that information has some relevance to the litigant, that's a concrete interest. And if there's unequal treatment with respect to that, I think that has to be an Article III injury. My friend also sort of made a casual remark that there's no material advantage that is conferred on people by these ads. That just defies common sense, economic logic, and the defendant's own actions. I mean, the only reason you purchase the ads and pay money for them is because they affect the marketplace, reach people they wouldn't otherwise reach, cause them to buy the product that they wouldn't have otherwise bought. And it's certainly a fair inference that if you're in the market, and it's been distorted in this way to the benefit of people who are different from you only based on a protected characteristic, that you suffer harm. And Judge Niemeyer, just to reiterate the point I was making earlier, trying to make about the Price case that you joined. It's a 1996 decision. I'd be happy to put in a 28J if you thought it relevant. But there, the white police officers conceded that they were not eligible for the promotion just based on their merit. But the mere fact that there was that it was a discriminatory policy worked some harm on them, and that was an Article III injury by itself. And here, and I think that's an answer to your question, Judge Rushing, but here the plaintiff says, the opposite, that she cared about the information, wanted to receive it on equal terms, and would have done something with it in the real world. And so I think the narrowest way to decide this case is just to say, at least on these facts, when you're alleging a particular unit that you would have competed for, but for this clear discrimination, that just has to be standing. Otherwise, you're opening the door to all kinds of profound ramifications.
Thank you, Mr. Taylor. We ordinarily come down to greet you. That's a tradition of the Fourth Circuit, and we always look forward to that and thanking you for your arguments. We're still following the protocols, and accordingly, we won't come down, but we'll thank you from the bench and extend our hands in some kind of abstract way. Enjoyed hearing your arguments. We'll proceed on to the next case. Winfield versus Montgomery Mall, and I guess we'll hear from Mr. Gold first.
morning. May it please the court. This case arose when a gunman shot 3 patrons during the attempted carjacking in the parking lot of one of the largest malls in the DC metro area. The gunman was a federal police officer with the Department of Homeland Security who'd been the subject of an extensive and widely publicized manhunt since the prior day when he shot his wife and a bystander in the parking lot of a high school within easy driving distance of the mall. Wall-to-wall coverage of the manhunt included reports broadcast via local radio, television, newspapers, and their websites and other social media platforms. The reporting included the name, description, and a photograph of the gunman, and a police report issued by the department in that location where the initial shooting occurred also included information about the vehicle, including the make, model, color, and the tag number that was an out-of-state tag.
Where was that included?
In a police report that was issued in the jurisdiction
I
neighboring
know, because
where
I
the mall
looked through
was.
all the publications and I didn't see any description of the car, year of the car, color of the car, and I don't know what that would have contributed, but I guess your argument is basically if they had publicized all that information, then the security people should have been searching everybody coming into the mall to see whether that car arrived.
Well, our argument wasn't that the security company should have been searching every car. However, the defendants conceded that had they been aware of this manhunt, they would have increased security on the day of the shooting, and they would have requested.
Well,
local
tell me,
police
just give me a
presence at the mall.
hypothetical about how having 8 officers instead of 4 officers or 2 officers would have prevented this shooting. I mean, this shooting took within the place a few seconds. There was a police officer nearby. He came to the scene, but the duty of the mall is to provide an invitee with a reasonably safe place to be. But this mall had, 6 entrances to it, over 5,000 spots, people come in and going. It's a huge mall. And so you have 30 security people around. People drive in and out all the time. And your suggestion is that somehow some officer should have been able to identify a car with the shooter in it and then done something at that point. I don't follow it.
So, Your Honor, the facts in the light most favorable to the plaintiff are that the shooter had been at the mall a minimum of 20 to 30 minutes, sitting in his vehicle, which was backed into a parking space.
Yeah, a lot of people sit in vehicles. They wait for other people. They sit on their phones. Somebody goes in and does an errand. I mean, just because somebody sits in a car, is that a suspect?
According to the plaintiff's expert, that is a suspect, and that's the type of a situation that is suspicious.
You have over 5,000 car spots in that mall, and they're going to go around and patrol and look for people sitting in cars and determining whether those persons are suspects.
Your Honor, that is precisely what the evidence in the light most favorable to the plaintiffs in this case says, that the security guard who was patrolling with a trainee that day in only one of 2 vehicles that were available for patrolling the lot, with the other vehicle sitting in a garage where it wasn't visible and might have acted as a deterrence, hadn't even gotten to that part of the parking area yet. Had they had more guards on duty, more personnel, and had they been operating at least one more vehicle, then someone would have driven through that location at least sometime before the 2 hours that it took.
Can I take a step back, Mr. Gold? You told us at the beginning, this all presupposes there's a legal duty, which is the thing the district court found there wasn't. And I guess you began by telling us this is a very busy mall in a very busy area, and just as a matter, I guess, of judicial notice, I am aware of this broad area. I mean, so within the general vicinity of this mall, I would not be surprised to learn that there is a Home Depot, a school, a large hotel, all kinds of other large retail establishments. And I guess what my threshold question is there any basis for saying that if the mall has a duty, all of those other large retail establishments in the vicinity didn't have exactly the same duty?
Your Honor, we're not asking for a broad precedent in this case, but under the facts of this case, the mall, because it had 5,500 parking spaces, was a prime target for a carjacking.
But I mean, again, I imagine that a Home Depot has 300 to 400 I mean, I guess I'm saying, are you identifying any basis in which we can say this mall has a legal duty under Maryland law, but an enormous Embassy Suites 6 blocks away doesn't, and an enormous Home Depot half a mile away doesn't, and a gigantic grocery store with a huge parking lot, or I mean, I guess is there any basis? Is there anything about this mall qua mall that means they have a duty, and every other large retailer in the vicinity wouldn't have had the exact same duty?
Well, part of the issue here is that the mall hired security, and part of the security's job was to patrol the parking lot, deter crime, and protect mall patrons. And so that's one of the distinctions. I don't know whether Home Depot has security
Well, I
that's
think the
patrolling their
question is,
lot.
I'm very interested in the question myself, and the question is, we're talking about a question of duty, legal duty under Maryland law. And the district court focused on that, as you know. So the question is, what is the duty that a retail establishment has with respect to its parking lots?
Your Honor, I'm glad you asked that question, because the mall owners and the property managers had a non-delegable duty based on at least one of 3 basic tenets of Maryland tort law. The first of which is the mall's actual knowledge of prior violent crimes that occurred in the parking lot within 3 years and earlier before this incident occurred. Those included stabbings, in the light most favorable to the plaintiffs, on 2 separate incidents in 2 different parking areas, and also a rape at knife point in a garage.
So what is your best authority for the I mean, I understand your friends on the other side don't even think the record creates a genuine issue about that, but let's give you that benefit of the doubt. What is your best authority for the proposition that 3 obviously horrible, regrettable, violent incidents over the span of multiple years satisfies this prong of the duty analysis?
Your Honor, it's the combination not only of the prior violent...
No, I'm asking you, what is the best case for the proposition that that creates this sort of duty?
It would be the Troxel case is one of the cases where that would create that type of a duty. And I would submit that...
What did the Troxel case hold?
The Troxel case held that there was a duty where a patron at a nightclub was attacked based on prior violence at the nightclub. I think the key here also is to, in addition to the mall's duty based on the prior criminal history, they also owed a duty to maintain the voluntary security measures that they'd taken, which was the installation of CCTV cameras and hiring security guards. So for that purpose, the mall knew in advance that they had an issue. They hired security, and they knew that they had a blind spot in their CCTV coverage, which the security company alerted them to well in advance of this incident, but they wouldn't provide the funding to increase the security cameras, which is one of the things that the security company had asked. I'd like to move on to the security defendants because I think the duty that in their instance is even stronger than the mall's. Under Restatement Section 324A, which is part of Maryland law, one who undertakes to render services which he should recognize as necessary for protection of a third person may be subject to liability to the third person for physical harm resulting from his failure to exercise reasonable care. There are 2 aspects of this. The mall owner specifically contracted with the security company for the very purpose of providing security. The contract specifies that the company is to provide, quote, a secure and safe environment for all staff and patrons. The contract required, quote, creating a visible presence to deter criminal activity, conducting patrols of vehicle parking areas, quote, to identify and deter security and safety risks.
Does this section of the restatement apply to preventing criminal acts of third parties? I know we're dealing with a security company.
Yes.
But the restatement section says if you accomplish your undertaking in a way that increases the risk, right? If you repair the light bulb in a way that makes it riskier for people who walk underneath, then you can be liable. So for it to apply, we have to there has to be, that the security company accomplished its job in a way that increased the risk to patrons of the mall of this type of violence by a criminal actor.
Judge Rushing, I believe that is only one of the three subparts of Restatement 324A.
It's the one you relied on in your opening brief.
Well, we also relied on the fact that the subpart 3, whereby the mall, if the harm is suffered because of reliance of the other or a third person from the undertaking. Here, the mall is the other, the contracting party that was relying on the security company to provide security services.
I thought under Maryland law it was reliance of the injured, the plaintiff, reliance by the plaintiff.
I'm sorry, could you repeat that, please?
I thought under Maryland law, reliance was reliance of the plaintiff,
No,
assuming that this is something that you raised in your opening brief.
under the restatement, it can also be the reliance of the other contracting party.
Has Maryland applied it that way?
Maryland hasn't applied it that way, but nearly every other jurisdiction that has considered this question has found that Restatement Section 324A creates a duty for security companies when a plaintiff is injured by third-party criminal conduct. Even this court's unreported decision from 1997, the Bias versus IPC case, held that the security company in that case owed a duty. Now, that case was tossed on summary judgment because of a causation issue, but the duty aspect, in this court at least, was held to be under Restatement 324A, which that case also recognized as being the law of Maryland. In addition to Section C, Subpart B creates liability where one contracts to perform a duty owed by the other contracting party to the third person. Here, it applies because the duty that the security company contracts specifically to provide security services, and it was the mall who, to protect the mall patrons. They voluntarily undertook the duty to perform a duty that the mall had owed to the patrons. In addition to so going back to the mall, the property owner owes three types of duties, at least two of which apply in this case when it involves criminal conduct. The first is to eliminate conditions that contribute to criminal activity if they've had prior knowledge of similar criminal activity. Now, granted, there hadn't been a shooting in the parking lot that was part of this record, but we do know that there were violent assaults, stabbings with weapons in the mall parking areas on prior occasions. And if they knew or should have known of events occurring immediately before the actual criminal activity. That's the Corinaldi case. The defendants here, had they been taking basic, easily to install types of monitoring of local news, could have made that imminent foreseeable harm lessened. In Corinaldi, the court held that where a hotel guest notified the front desk 10 minutes earlier that someone at a party had a gun, that 10-minute delay was sufficient to create a duty when the person at the party shot someone else. Here, the shooter was present in one of the mall's parking lots for a minimum of 20 to 30 minutes. We don't know how long that shooter was there. It could have been for hours because the patrolling vehicle, the one patrolling vehicle, when they had two, hadn't gotten to the location, the card reader location in that lot by the time the shooting occurred. There are 44 checkpoints. They'd only gotten to the 33rd or 34th when the shooting occurred.
It baffles me to figure out, based on all those news reports, and I think I looked at every single one of them, that anybody could identify miles away from the school shooting, that anybody could identify somebody in a parking lot sitting in a car.
Your Honor, I apologize.
The car was not described in the news reports, the color, the year, his age, and there was a picture there of him, I think, in the news reports. And they said, if you have any information, supply it.
Your Honor,
and it seems to me, here's a 54-year-old man, or 52-year-old man, whatever, he drives in the parking lot and he's sitting in the car where there's 5,000 other cars. And you're suggesting that somehow somebody would anticipate a shooting and go over and apprehend him for something when they don't even know if that's the right guy.
Your Honor, I apologize because in our joint appendix, it turns out that a portion of the exhibits that were submitted for summary judgment in this case were omitted inadvertently from the joint appendix. But in the appellate record, the record on appeal, there is an exhibit from the admissions.
What's the appellate record different from the joint appendix? You said the appellate record?
Yes,
Where is the appellate record?
it's,
You just mean the district court record?
yes, the district
Oh,
court. I'm
that's
sorry.
that record in the case.
I'm sorry, the record, yes,
I
the
got
record in
you.
this case,
I got
that
you.
just,
All right,
that,
fair
which I understand was transmitted to this court in full before we filed our joint appendix, included in docket entry 84 of the record from the district court, in the motion for summary judgment joint appendix G part 2, there was a request for admissions. In exhibit 8 of that joint appendix in the district court, page 64 of 130, was the Fox News report, which included the make, model, color, and vehicle tag number.
That was the day after that was the day of the shooting, right? You don't have the time on that. The Fox News report was the day after the school shooting, the day of the mall shooting, right?
That's correct, Your Honor.
Okay. And there was testimony that no one can say that that information was available before the shooting.
No, however, even the
That was
Montgomery-
the testimony that the expert couldn't say that that was available before.
That's correct, Your Honor.
All right, thank you. I think you have some rebuttal. Mr. Gallagher?
Good morning, Your Honor. May it please the court, Brian Gallagher, and I'm arguing on behalf of the appellees in this case. I represent a Montgomery Mall owner and Westfield LLC. My colleague, Ms. Bardot, she's going to be handling a discrete issue relating to the PSC appellees in this case.
Just the PS, that's the security company?
Yes, sir.
Got it.
Your Honor, the events that took place at the Montgomery Mall on May 6, 2016 are undeniably tragic. Nobody should ever have to go through the pain of such a random act of violence. However, the appellant's attempt to hold the appellees liable for this random act of violence is incompatible with the law and the facts of this case. The undeniable facts of this case, or the undisputed facts of this case, are that on May 5th, 2016, Eulalio Tordell went to High Point High School with the target of his estranged wife. He shot and killed her. Although he did shoot another individual, that individual attempted to intervene between the confrontation between Tordell and his wife. Of the 20 news articles that were presented in the joint appendix, if you read through every single one of them, 19 of those 20 are from prior to the mall shooting. They describe this, and it's not they, this is not the media. The media is reporting what the chief of police of Prince George's County described this as. The chief of police described this as a domestic-related incident. He said that this is not an active shooter situation. Now, over the next 18 hours, Mr. Tordell, from all we know, based on the record, drives around. He drives down into Virginia. He drives up into Frederick County, Maryland. For 18 hours, he apparently drives around. Now, in those 18 hours, he could have gone anywhere. He could be in Florida. He could be in Texas by then. But what the appellants would have you believe is that it was foreseeable that Mr. Tordell would not flee the area. It was foreseeable that he would stay or come back to the area and go specifically to this establishment.
But wait, that doesn't sound like a duty argument. That sounds like a no breach argument or a no proximate cause argument. And the district court dismissed this on a duty theory, not a causation or breach theory, right?
You're correct, Your Honor. And the arguments for each kind of meld into each other a little bit. And there's a little bit of an overlap, and I'll get to the overlap of the standard of care in a second. But speaking specifically to what the appellants argued here, generally speaking, as this court knows, there's ordinarily not a duty to protect patrons of a business establishment. However, a A special relationship between a business owner and a patron can be established if certain circumstances are present. The owner controlled the dangerous defective area. 2, the owner had knowledge or should have known of the injury-causing condition. And 3, the harm suffered was foreseeable. Your Honor, the appellants made an argument that the district court incorrectly found that there was no duty based on the allegation of prior incidents in this case. Now, specifically, they allege that these violent prior incidents consisted of a rape and 2 stabbing incidents. Your Honor, as the court knows, prior incidents must be similar and recent, similar in nature and recent in time. The rape incident happened in 1991, some 25 years before the incident that is before this court. Under no circumstances can it be considered that that was a recent event that could be used as a basis to impugn liability. Now, going on to the issue of the 2 different of the stabbings, for a dispute of fact to be able to overcome summary judgment, this court knows that it must be a genuine dispute of a material fact. I will first posit to you that this is not a genuine dispute of fact, that this is actually a single incident that the appellants are attempting to create into 2 separate incidents. As the record reflects, the mall representative was deposed. In his testimony, he said that in the 5 years prior to this, he went back and conducted a review, and they were able to uncover a single stabbing incident that occurred in 2013. When Mr. Bazan was deposed, he stated that in the time that he worked there, he remembers 1 other incident of violence. It was a stabbing. He wasn't very sure of exactly when it took place, and he believed, I believe his word was he believed it happened in one of the parking lots. Now, Your Honor, if you look at, and I'm sorry, let me back up one more second. If you then look at the deposition testimony of the appellant's expert, he himself says that he was provided information that there was a single stabbing and a single rape incident. Now, I posit to you that they are talking is not a genuine dispute of a material fact of whether there was 1 or there was 2. It seems to be that everybody's talking about the same incident and that it's not actually a genuine dispute of fact. However, Your Honor, even if this court were to determine that it is genuine, I would posit to this court that it's irrelevant because it fails to meet the standard of being similar in nature. And I say this relying on a long line of cases that were cited in our brief, in which the incident must be similar in nature. At no point are there any incidents of shootings at the mall. The record is devoid of any allegations of shooting. The record is devoid of any allegations of carjackings, which is what the appellants argue happened here, is that there was an attempted carjacking and that there was a shooting. There is absolutely nothing in the record to reveal that there was any shootings or carjackings that have ever taken place at the mall. Now, if you look at the cases that I cited, for instance, one of those cases being, I'm not going to pronounce this accurately, Negito versus First National Bank. The court found that evidence of prior robberies didn't put the bank on notice of a customer would be shot. There are several other cases just like that where the court determines that just because there was an incident before, it must be similar in nature to the recently complained about incident for it to be relevant and to be used as part of establishing that duty. Your Honor, moving on to the next issue of, and this is something that I briefly touched on a moment ago, is the appellants are attempting to establish a second prong by alleging that the mall defendant should have known of Tordell's violent tendencies. That they should have known, and I'm quoting here, that he would attempt to steal a vehicle to replace his that he would attempt to steal a vehicle to replace his rental vehicle. There is absolutely nothing in the record of this case that would make anybody believe that there was the possibility of a carjacking to take place, whether it be on the mall's grounds or anywhere else in the area. There is nothing in there to believe that it was foreseeable that Mr. Tordell, who committed a crime, a specific crime that is described in the media as a targeted domestic violence incident, that occurred 15 miles away, 18 hours before, that the mall should have been on guard of that individual attempting to come and carjack at their location. Your Honor, the appellants raise two more issues regarding the duty. They allege that the mall should have known about Tordell's presence at the mall that day, and they also allege that they failed to maintain adequate security. Your Honor, both of those issues go straight to the standard of care in this action. Both of those allegations allege that we failed to provide adequate security. That phrase is repeatedly mentioned in their brief. How do we know what would be adequate security other than by the testimony of a security expert, somebody who could testify that this is the standard of care? And Your Honor, as we cite to in our brief, their security expert was wholly incapable of identifying what the standard level of security is for a mall in that situation. I walked through with him. If you're saying they should have staffed up, you're implying that they weren't adequately staffed to begin with. What is a baseline level that they should have had for this day, for this time of year? Could not answer that, said that was beyond the scope of what he was asked to do. So if they cannot establish a standard of care, they similarly can't establish and meet the element to prove a duty that we failed to meet that standard and or that the presence on that day should have been identified. Your Honor, unless this court has any further questions,
All right.
I have nothing further.
All right, thank you, Mr. Gallagher. Ms. Bardot?
Thank you. My name is Heather Bardot, and I represent Professional Security Consultants and Professional Security Concepts, two of the appellees in this case. Although it has been common for everyone to refer to them jointly as PSC, they are not one and the same. And just for the record, I want to be clear that the entity that was contracted with the mall was Professional Security Consultants. Professional Security Concepts has no connection to this case. Mr. Gallagher has addressed the issues in the appeal, which I think jointly apply to both of us, and I adopt those arguments on behalf of my clients. I want to take the limited time that I have to address the appellant's argument that the security companies, my clients, owed a duty to the appellants to protect them from a criminal act of a third party, in this case, Mr. Tordell.
Ms. Bardot, could I ask you to address specifically restatement 324, big A, little a? Because I just pulled up your brief and I was trying to remember what your response to their argument about
Sure.
little a was. And I think your brief only responds to little c, which is not the argument they make. So could you explain to me why they're not covered by little a?
Yeah, well, here's the problem, right? Starting out at the beginning in the complaint, they never made an allegation of sort of what the courts refer to as a negligent undertaking, a 324A allegation. That's never made. That comes up by way of the district court on the motion to dismiss, pulling that out. It's not even an allegation in the complaint. And so we move on, and they brief this issue in this court, and I would submit when they submit their original brief citing to 324A, it is completely unclear which section of that they even refer to in their original brief.
Well, except their brief is literally quoting from little a. I mean, so that's on pages 27 and 28 of their brief. But I guess I'll just ask you what I think of as this.
Sure.
So tell me what's wrong about this analysis. One, your client, who undertakes for consideration to render services to another, the mall, which he, your client, should recognize as necessary for the protection of a third person or his things, the shooting victim, is subject to liability to the third party, the shooting victim, for physical harm resulting from his, your client's, failure to take reasonable care to protect his undertaking if his failure to exercise reasonable care increases the risk of such harm. So I know that Maryland has not formally adopted that, but for purposes of my question, assume for the sake of argument that Maryland would adopt that statement.
Right.
What part of that means that your client doesn't have a duty?
Right, and thank you for clarifying that, because I would have addressed first the fact that it hadn't been adopted and that it should be adopted, and there's a lot of policy reasons and so forth. But to answer your question specifically, what I would tell you is that, first of all, you've got to look at the paragraph before you get to little a, right? And I think this goes to the point that Mr. Gallagher raised, that you first have to find that there's a failure to exercise reasonable care. And the record in this case doesn't
Well, no,
even...
but that's a breach causation question. That's not a duty question. This
Okay.
is the language that creates the, I mean, look, I guess I'll, full cards on the table. I suspect they might have a really, really difficult time proving breach and causation against your client, but I guess what I'm less clear about is the district court's conclusion that your client didn't owe a duty in the first place.
Right, well, I think that the court didn't find that 324A provided a duty, and absent that, what the court found was
Why
that...
not? Like, I'm not asking what the district court did. Why do you think that again, positing everything we said about assuming Maryland would adopt this provision, why doesn't 324A create a duty on your client in this situation?
Positing that Maryland would adopt it, what A says is that they must show that the failure to exercise reasonable care increased the risk of such harm. And I would submit that there is nothing in this record, and this was addressed in our brief, that would establish that anything my client increased the risk of harm to the plaintiffs.
Totally agree with that, but that to me sounds like a breach argument, not a duty argument.
Well, I mean, maybe it is, maybe it's apples and oranges, but at the end of the day, I think that if they can't show, let me just cite you to...
I suppose, wouldn't you say that increasing the risk is a different duty than maintaining safety or precluding injury?
It is a different duty. It's more like a failure to act. I would refer the court to a case that I think is helpful that was not cited in our brief. I was updating the research to make sure there'd been no change, and I came across a case, Sheridan versus United States, 969 F. 2nd 72, 1992, and in that case, they were trying to determine whether or not there was a duty at all based on the same sort of restatement. And they said that prerequisites to having a duty would be that the something that the defendant did increased the risk of harm or induced reliance. You have to have those first before a duty attaches. So
I guess the reason I think it might matter whether this is a duty or a breach issue, because again, I think that they're going to have a very hard time showing a breach on these facts. But let me give you a hypo that illustrates why I'm worried about saying there's no duty, right? So I want you to imagine a scenario where a security officer is sitting like in the room looking at the cameras, right? He's in the room with the cameras pointing at the parking lot. And on those cameras, he sees a man get out of a car. The man is wearing body armor. The man is clearly like kitted up with a full Rambo-style kit. The man slowly walks to the trunk of his car. He opens it up and he pulls out an assault rifle and several other guns. And then it's a huge parking lot. He starts very slowly walking towards the mall. And the guard does nothing. Nothing. He does, and I'm not asking him to be a hero and get shot. I'm asking him to pick up the phone and call the police or something like that. But he does not do a single thing in that moment. And the man goes in and there's a mass shooting incident. Why isn't the logic of your position that in that situation, that if we say there's no duty, I don't think there's any liability even in that situation? And why am I wrong about that? Or why from a duty I get from a breach perspective why that hypo is very different from this case.
Right, but
from a duty perspective, why is it different?
you still have to figure out where does the duty emanate from, right? So a normal person under those circumstances doesn't...
it's your client with your contract that has all these things, like we contract. I mean, you know the language of your contract. You say
Right.
you provide security to the mall patrons. The contract is exactly the same as yours.
I still don't think that my client has a duty to a third party to provide them protection from a criminal act. I don't believe Maryland law stands for that proposition. I think the district court was right on that. I don't think 324A would be adopted to override this longstanding law under Maryland precedent. I just don't believe, there's no case where that's been done. And I will say that the cases such as the Bias case, which the appellees relied upon, was 26 years ago. That's the case where the court says, well, we think that Maryland would adopt this. And in 26 years, that still hasn't happened. And so without any Maryland precedents saying, yes, we would find that 324A overrides our longstanding jurisprudence that says, even in your scenario, I don't have an obligation to intervene. I just don't think it would do that. So I don't think that the cases are different because I don't think that duty would ever be imposed under Maryland law. So I hope that's responsive to your question. And I would just note too, just to try to close this gap, under 324A, little section B, the appellees have argued that we had undertaken to perform a duty owed by the mall defendants. Again, this is not an argument they ever raised before. I don't think it's been preserved, but to the extent that the mall defendants don't have a duty, undertaking their duty certainly would give us no obligation under that section. And then the last section, the harm is suffered because of reliance of the other or the third person upon the undertaking. I would submit that no harm was occasioned by reliance upon my clients, and that the plaintiffs have pointed, or the appellees have pointed to nothing in the record to show that there was any reliance upon my clients by them to do anything. There's not even anything that suggests they knew about my clients or the level of security that my clients would provide. And at the end of the day, my clients were an observe and report company. They had no batons, no guns, no mace. All that they could have done was observe and report. And as was mentioned, 50 yards away, there's a marked police cruiser there. Even he didn't respond or know of this incident. So I hope I've covered everything. It's a lot.
Thank you.
Thanks.
Mr. Gold?
Thank you, Your Honor. Regarding the foreseeability question that the mall owner was making.
We'd hear more clearly if you were willing
Thank
to.
you.
You don't have to take it all.
No,
but-
thank you. Regarding the foreseeability issue that the mall defendant was addressing, this was a trained police officer with the Department of Homeland Security who would have known that his rental vehicle had GPS tracking and therefore was likely to be trying to get a different vehicle. And the best way to do that was a carjacking. And that's not only what happened at the Montgomery Mall, the attempted carjacking, but that's where he was ultimately captured, was at another mall where he also tried a carjacking. And the standard of care that applies at a minimum is to monitor local news, to stay aware of local events. And the
Yeah, you know,
duty
but
is
this
to-
sounds sort of like you're arguing for sort of a good Samaritan law. I mean, the questions we keep pressing about duty, the idea is if a bystander, taking Judge Hyten's example where the Rambo type of guy reaches in for his assault weapon and a bystander in the mall sees it and does nothing, we don't impose a duty on him to be a police officer. And Maryland has adopted that position with respect to landowners and so forth. In other words, there's only so much that you can expect of security officers that are not armed, that they're there to call in if they can, but there's no duty imposed on them to get involved and prevent criminal acts.
I'm not suggesting that the security company defendants should have intervened and physically made contact with this person, but there was ample time for them to have seen him sitting in his car. The patrolling officer said specifically that that would have raised a red flag for her. If she'd seen someone sitting in a vehicle for 20 minutes, backed into a space, that would raise a red flag. They could have
That's the same
contacted
duty
police.
you're addressing. In other words, does a person have a duty to act on somebody sitting in a car who's suspicious?
A security guard absolutely does. It's in their contract. They're supposed to be.
Well, you're not the beneficiary of contract. You have to rely on the tort law, the extension of duties to third persons to prevent criminal acts.
But they are a third-party beneficiary of the contract. The contract specifically requires that the security company provide services to protect mall patrons in the parking lots. And the contract, is what creates the duty here. And every other jurisdiction that has considered that has found that 324A creates a duty for a security company with regard to criminal conduct.
But hasn't Maryland rejected the idea that you can create a duty, a tort duty to a third party via contract?
Not that I'm aware, Your Honor.
I think Maryland has rejected that idea that a contract creates a duty to a third party. Now, they haven't specifically addressed this restatement question, but that seems to counsel against us reaching out to say, despite that, they would interpret this restatement and adopt it in the way that you suggest.
I believe that they would, and part of the reasoning is because although the Maryland Court of Appeals hasn't specifically adopted Section 324A, it's been cited in a number of Maryland cases by the Court of Special Appeals, the Intermediate Appellate Court. And again, I would refer this court to the case that it decided in an unpublished opinion in 1997. And there's another case that we cited in our brief from the U.S. District Court for the District of Columbia that actually involved this very defendant, PSC. And that court held that they had a duty to protect patrons at Union Station in D.C. That was in their contract. The duty is created by virtue of their contract. And just with regard to the question as to Judge Hayden's concerns that we may not be able to prove breach and causation, that's not the issue in this case today. The issue in the case today is whether there's a duty and whether it was foreseeable, because there's several elements of duty, all of which have to be considered. Some of the elements include whether, not just foreseeability, but whether the specific plaintiffs actually suffered some harm, which clearly happened in this case. The degree of certainty, the policy of preventing future harm, which, I think, as Judge Hayden's hypothetical was, if a security company who's supposed to be monitoring sees a gunman walking toward the mall, they absolutely have a duty to at least try and contact authorities to intervene. And the extent of the burden up to the defendant. In this case, all they had to be doing was monitoring local news. It's not a huge lift. They actually had something called the Mercury social media platform device, which would have allowed them to have seen, various tweets.
That's a strange duty. A commercial establishment, retail establishment that has hired security, they have to monitor the newspapers for crimes committed in the area 12 miles away, 18 miles away?
The security company defendants need to be doing that.
Pardon me?
The security company defendants need to be doing that. And I submit that the mall does as well. Because even though the mall has hired the security company, part of what the mall needed to do was to make sure that the funding that they
Well,
provided.
I thought the restatement talked about increasing the risk and not protecting against criminal conduct.
That is
I'm
just.
thinking that in the DC area, including Northern Virginia and Maryland, there's crime committed all day long. And if you monitored the newspaper reports of those crimes regularly, the question is, what do you do with that information? And how do you handle it? And what's reasonable? I think that's a strange duty to impose.
I think the information here is that you're not going to be concerned about, drug gang killings, for example, unless the gunman.
Well, why not? We have an MS-13 problem in the DC area.
Unless the gunman has training and is supposedly looking for a vehicle to carjack. That's the difference in this case. And I would submit that any type of violence like that occurs in the DC
but again,
metro area.
I don't want to take you off track at the end of your argument, but we agree there's nothing in the record that would have put the mall or the security company on notice that this man was in a particular car, was trying to carjack another car, or anything like that, right? There was a news report that said he left a car at the scene, maybe. There's nothing saying he's in a rental vehicle. He's looking to carjack. That was all after the fact, right?
There were photographs of him. Yes, you're correct. That was after the fact. But
Okay.
there were photographs of him.
I'm just saying that doesn't distinguish your drug trafficking, right? Like if there's violent crime, and that pretty much would mean that the mall and its security company, if there's violent crime in the area, they should be on alert. If the photograph's in the news.
This is a particular example because of the training that the gunman had as a trained police officer. He knew that his vehicle had to be gotten rid of because of the GPS tracking, and they knew that he was still on the loose. He'd been on the loose for at least 18 hours.
Okay. I think we understand the arguments, and I think at this point, we would come down and greet counsel. We're in the nuances of Maryland law. And, I don't know. I'm from Maryland, but I'm a stranger. I've been on this court so long that they isolate me from Maryland law. But anyway, we appreciate your arguments, and we would normally shake your hands. We'd like to greet you in that respect and welcome you back at another time, and when we will be able to shake your hands. Thanks very much. We'll adjourn court for the day.
Thank you.
Thank you.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.